Welcome back to this week's edition of Freedom and Prosperity Radio, the weekly radio news magazine that you can repeat along with home with me in this little routine that I do. I caught you. I changed it up a little bit. VirginiaInstitute.org. Joining us now, one of my truly favorite people in law. And there are, believe it or not, quite a few, and some of them are even related to me. Matthew Hardin is not related to me, but he is one of the great constitutional lawyers in the Commonwealth of Virginia, and I'd argue in the United States. He's never needed to defend me in court, but he is a great one. Former Commonwealth's attorney for Greene County, and they are the weaker for it, but he is out there working for us. MatthewHardin.com is where you find him online. Welcome back to Freedom and Prosperity Radio. Matt, how are you doing, sir?
Wonderful, Joe, and I'm looking forward to having a chance to defend you when the left realizes you're still out there.
That's right. Well, but it just is an abstract, and it's not really why we set up this interview, but I've said in the past, every time the big government gets like this, eventually somebody is going to wind up being Nelson Mandela. They're going to be that person who it's the Rubicon, they cross it, and then all of a sudden it's like, hold on, you arrested him for what? And that's why defense attorneys are so important to the Constitution, because our system is supposed to be built with enough triggers in it legally that the defendant is the one that's presumed innocent and has all the recourse to prove it.
That's absolutely right, and that's, I think, the problem with the situation we're in right now with the government shutdowns and a lot of other issues is we're assuming that people are transmitting the virus until proven otherwise. We're assuming that businesses need to be shut down until proven otherwise. And that's not how this country's supposed to work. It's supposed to be innocent until proven guilty and freedom until proven that you can't handle your freedom. And we've sort of reversed everything.
Matthew, it's scary. It's a virus. We've never had a virus before. I'm making light just for contrast, but let's talk about what this has done to the judicial system, a system that was already struggling to keep up with caseload as it was before COVID-19. How backed up have we become in terms of getting people that constitutionally guaranteed speedy trial in front of their peers?
Well, what we did for a couple of months in the beginning, they outright closed the courts completely to both civil and criminal trials. They have sort of reopened the courts, but they're not having jury trials. They canceled jury trials for quite some time, and then they opened up for a month or so, and now they've shut down jury trials again. The problem is that the courts are not only not having jury trials, but that they're holding people pending a jury trial that they will never schedule due to the coronavirus, and that they're saying that speedy trial deadlines don't apply because these are special circumstances. So it's not that they're violating your speedy trial rights. They've just decided that you don't have any speedy trial rights in the current circumstances.
So people are just literally rotting in jail, separated from their family and friends, never mind being in a Commonwealth where we'll take all your assets because you might use them to defend yourself without a conviction. But now we're just throwing people into a hole and forgetting about them?
We have people facing felony charges in Virginia who have been facing felony charges since March. And they're being held because they say, oh, well, you're not eligible for bail because you are charged with a violent felony, which, fair enough, except that they won't prove them guilty either. Because if you invoke your right to a jury trial, they say, well, it's not safe to have a jury trial, so we'll just hold you in the meantime. So the people that have been held for months on end since March, it tends to be very violent felonies. But it's working its way down because, again, they opened up jury trials for a little bit, and then they shut them down almost immediately again. So people that have been arrested in July and August and September, they're running into the same problems. And it's trickling down into the civil system as well because they have to prioritize criminal jury trials whenever they decide to have jury trials again. They're going to prioritize criminal trials. And so if you're a civil litigant and you've been hurt in a car accident or something like that, and you want a jury trial, right now we're scheduling them into 2022 and 2023.
Holy cow. And if you've been damaged in some way and you're just trying to get recourse, I know that you believing in right is right, but gosh, that is just. I've made the argument that we have 3 times as many citizens as we did 100 years ago, and the same number of legislators. People have heard me say that before, but I wonder if we haven't done the same thing with our courtrooms. We have so many more citizens, and nary hardly any more courtrooms than we did 100 years ago.
That's a good point. And it seems to me that this is a way to essentially bully people into giving up their jury trial rights because. Yeah. Well, we're not really taking it away from you. We're saying we're going to have a jury trial as soon as we possibly can, and we'll mark that down for July of 2023, unless you want to waive your jury trial right. And so that's how people, quote unquote, voluntarily waive their rights, even though the choice isn't truly voluntary.
It sounds like, and obviously we're talking about some of the most violent felonies, but at some point it's going to wind up catching more of them, I've got to believe. It almost sounds as it backs up more that you'd be able to get a parole hearing before a jury trial if it keeps going like this.
It's a very good point. I think that we've always had this situation with certain felonies, the low-end felonies, the drug offenses, where it is quicker for you to get out of jail if you plead guilty than if you wait for a trial and are found not guilty to get out of jail. We've always had that problem with lower-level felonies, and it's something that a lot of left-leaning groups and libertarian groups have fought for a long time. They said it encourages guilty pleas, whether you're guilty or not, because you get out quicker if you plead guilty than going to trial. What we're seeing is an escalation of that system, where it used to be a few nonviolent felonies you might get out of jail quicker by pleading guilty. Now, when we're holding people for more and more and more months without even scheduling a trial, it's working its way up and affecting more and more people.
Doesn't this also feed into the, criminal justice system isn't working anymore? That, believe it or not, even President Trump has been one of the very, very few politicians, never mind whatever political party he was in, to really look at trying to reform our criminal justice system so you weren't just throwing away and disproportionately, and then you hear about the school-to-prison pipeline and all the other rhetoric that some groups will use. But, I mean, this kind of stuff feeds that beast, doesn't it, Matt?
It absolutely makes the problem worse. And I think what we've seen in Virginia, we had some problems in Virginia, I think, because our criminal justice system needed modernizing, but we also had one of the lowest recidivism rates in the country up until last year. Now we've seen the General Assembly do things like taking sentencing decisions away from juries and putting them back in the hands of judges so that you can't, as a member of the community, have a say in what the appropriate punishment is. But these leftist reforms to give more power to judges and take it away from juries is sort of running up against the coronavirus rules, where we say, oh, well, we want to take all power out of the hands of the jury, and then, but we're also not even going to bother to impanel a jury because it's too risky right now. So it's not well thought through, and it's not harmonized sort of what the goals are right now.
Well, couldn't, considering, the process and procedure for a jury trial in general, can't we come up with a way where the jury boxes have, the plexiglass or in some way, shape, or form? Because believe, as God is my witness, I don't want to see them try to do a Zoom jury trial. But some way that the jury can be, safe, from the droplets in the air, or however they're saying these days that COVID-19 is spread?
It's interesting what we're seeing done at this point. The Supreme Court of Virginia said that every state court has to come up with their own plan for how to seat juries in their courtrooms. And so you see a lot of the courtrooms are being reconfigured right now with the idea that we can spread ourselves out or we can put in plexiglass or that sort of thing. It works better in some courtrooms than others because some courtrooms are bigger. In the city of Richmond, I think their courtrooms are very modern, and plexiglass, for example, works quite well. Here in Greene County, the courthouse is one room that was built in 1838, and it's a little harder to install that. So that's one problem, is each courthouse is different. We also have this problem in federal court. They have giant courtrooms, and the jury can sit where the audience would normally sit and spread out. But can they hear is one question, and can they see the evidence? If I'm holding up a knife that I claim is the murder weapon, and you're sitting 50 feet away in the back row, I'm not sure that you're really equipped to make a decision based on the evidence presented to you in that situation.
Or even the facial gestures of a witness testifying and that kind of thing. We're visiting with Matt Hardin. He's criminal defense and political law specialist at MatthewHardin.com, former Greene County Commonwealth's attorney. Matt, you mentioned 1838. It just struck me, and it's completely tangential. We had courtrooms during the Spanish flu. What did we do 100 years ago when that pandemic was running across the United States?
Well, we fought the American Revolution during a smallpox epidemic as well. So I think that men were a little bit tougher back then. But there were a few shutdowns. There are some famous examples. Pittsburgh and St. Louis shut down for a week or two in the height of the Spanish flu. And the people that were advocates for shutdowns this year, or last year now, said that we should follow the wonderful examples of Pittsburgh and St. Louis in 1918. But if you look at the data, they did it for a week or two during the height of problems when the city was really on edge. They didn't shut down for 9 or 10 months or even a year, completely ceasing all government functions. They did targeted shutdowns back then. It's
an amazing time, and you talk about the courtrooms and how this has been pushing folks to accept a non-jury trial or just plead out their case. Because they could be facing who knows how long emergency situation with this. What do you have any statistics on how many people have, and is it noticeably different than would under a normal circumstance waive their right to a jury trial or just straight up plead out their case?
We don't have statistics. The Virginia Supreme Court keeps track of how many cases are sort of in the pipeline and backlogged. And at one point, I think it was 60,000 cases a month back in March that were being added to the backlog every month. Now, we have sort of partially reopened since then, so it's a little hard to say what the stats are right now. Mm-hmm. We also have this situation where for minor felonies right now, judges who would not have granted bail before do grant bail now because there's this idea that the prison system is very dangerous. It's infested with coronavirus, and we shouldn't possibly put people in prison. That causes problems on our streets when we don't lock people up because we're letting everybody out on bail now. That's sort of the opposite of what you see at the higher end of the spectrum. With very serious felonies, people are being denied bail and locked up for months on end, whether they deserve it or not, whether there's evidence beyond a reasonable doubt or not. With minor felonies, though, it's almost catch and release at this point because we don't want people spreading coronavirus in the jails. And so that's another example of a two-tiered justice system.
Matthew, I want to ask you because, obviously one of the things that has come up to me is like, well, why don't they just do it like our, local governments are doing all their meetings on Zoom? But we've, as the General Assembly has started up this week, heard horror stories of people who can't get in to bear their testimony, that have been invited to through these Zoom meetings. Even Attorney General Herring at the start of this said he would nod to the idea of Zoom meetings for emergency procedures, but he cautioned, even Mark Herring cautioned against using Zoom meetings as the standard operating procedure for governing in any circumstance. Now, he's since backtracked because somebody said, hey, we're all Democrats out here, hook a brother up. And he has sort of said, well, continuity of government, blah, blah, blah. But, we've seen how badly, testimony is given and the right of petition is really scrambled in COVID-19. And I worry that if it wasn't the intent, it's certainly somebody saying, hey, this is a great idea.
Well, we're getting a little bit smarter about how we run Zoom meetings now than we were in March. I think everybody's getting more used to it, both on the citizen side and on the government side. So the meetings are going slightly better. But I do think that Zoom has all sorts of avenues to silence people. For example, the mute button. It's very obvious if you don't want to hear from somebody, well, the mute button's right there. And some folks will admit to using the mute button, and others will. It's technical difficulties. But we've tried, for example, having Zoom trials. In Texas, they actually tried doing jury trials by Zoom, and it was a colossal failure because the jurors couldn't see what was going on. You couldn't ensure that they were even remaining at their desks, much less paying attention to the evidence. So, Zoom is never going to be a substitute for actual civic participation.
Yeah, I from your lips to the decision makers' ears, would you hope that somewhere somebody can at least get this into the courts of justice system or committees or whatever they're calling it now, so it sounds politically correct?
I was very optimistic in the beginning that the courts were going to save us from what is really a complete abrogation of the Constitution. I mean, everybody says that in tough times the Constitution stretches a little bit, but what we've seen is basically we ripped it up. We've taken away people's rights, not just for a few weeks, but for months on end. We've suspended the right to jury trial, the right to access the courts, the right to petition the government. And I would have hoped that the courts would have been our bulwark and they would have stood up for us, or that our politicians would have said, okay, enough is enough. But 9 months into this, 10 months into this, I haven't seen anybody with the courage to say, how about we go back to that fun little Constitution we used to have?
Yeah, because I think some of the subtext is, as you mentioned at the onset, were infectious until proven cured, to play on the legal parlance. But that's I worry about what's the old Soviet term, normalization of this kind of behavior. And when we come out of COVID-19, we're just going to expect the governor to tell us when it's okay to do things.
Well, that's exactly the problem. I think that if you look at this epidemic compared to a lot of other epidemics, what you're going to see is that this is not so unique. What is so unique is our response. And as people become sort of inoculated, as it were, to the government overreacting in this way, it will become more and more common. I mean, it's COVID-19 this year. It's going to be something else in 2024 and something else in 2027. And it's going to be the same justification of we're not doing this just because we can. We're doing it to save lives. And I worry what precedent we're setting.
Well, Matthew, I mean, we heard it after Virginia Beach that gun violence was a health concern. And so now you add that to, what we've learned now and what the government can do. When does gun violence become a public health emergency and they start confiscating firearms based on the fact that, it's the new COVID-19?
Well, remember the protests over the summer with the Black Lives Matter movement. That was okay. It wasn't okay to protest the lockdowns, but it was okay to protest with Black Lives Matter because racism is a public health emergency. I believe the city of San Diego has passed an ordinance with their city council calling racism a public health emergency. So, and we heard the rhetoric, 5, 10, 15 years ago about global warming was a public health
That's another
emergency.
one.
What we've done is we have taken all meaning out of the word emergency. It used to be, World War II was an emergency, and I think everybody will admit that was an emergency.
Yeah.
But when you call Thursday an emergency, it takes all meaning out of it, and that's why we see so many emergencies. And of course, the government claims it can do whatever it needs to in an emergency.
As one of my fictional heroes, Arthur Dent, once was known to say, I just can't get the hang of Thursdays. Matthew Hardin, what about just to finish up here on the criminal proceedings, what have you been advising clients to do in these cases if they're arrested? And let's face it, you're there defending, you said, violent accusations. We watched the rape on campus, Donnybrook, in Rolling Stone magazine. Accusations can be made. The reason we have court proceedings is to prove whether or not they're true or not.
Well, what you see right now is that everybody who wants bail in the Commonwealth of Virginia and every good defense attorney in the Commonwealth of Virginia that wants to get their client bail, everybody brings up COVID and says, well, we really need this person out of jail because they've got, a very sensitive immune system. After years of drug abuse, they have a very sensitive immune system. And coronavirus might kill them, so we need to get them out on bail. Or they're aged, or their liver is unhealthy, or lots of other things. And so you see all the defense attorneys, and I'm one of them. I argue that my clients need bail because of COVID, because that's the situation that we find ourselves in. Again, is that good for society at large that we have just decided we're going to let a lot of felons out because of somewhat overblown coronavirus concerns? Conversely, we're locking other people up because we're not prepared to grant them bail, but we're also not prepared to grant them a trial. I don't think that it's good for society, but I think that you see smart attorneys and smart pro se defendants taking advantage of it. I think that if you go into most of the circuit courts in Virginia right now and you observe a few bail hearings, I bet 3 out of 4 bail hearings, they're raising COVID as a reason to let somebody out of jail.
Matthew Hardin, again, it's MatthewHardin.com, and please engage him. Hopefully you never need his defense services, but he's great, and his mind works at a different level than most. We appreciate everything you do, and have a great weekend.
You too, Joe.
And thank you for tuning in this week to Freedom and Prosperity Radio. For all of us here at the Virginia Institute for Public Policy, now is the time as the General Assembly's in session. Stay tuned. So long, and thanks for all the fish. Thanks for all the fish. Thanks for all the fish.